as successor in interest to Agnoletti Properties, LLC.
Good afternoon, Your Honors. I'm Justin Adams of the Nashville Bar for Appellant Rose Legacy, and I would respectfully request 3 minutes of rebuttal.
3 minutes.
May I proceed?
Please.
Thank you, Your Honors. Rose Legacy has asserted several issues in this appeal. I want to begin by focusing on Rose Legacy's challenge to Genash's, or I'll call it the tenant's, first material breach defense. Rose Legacy asserted a counterclaim for rent, interest, and late fees that accrued after the tower crane came down and the license agreement expired. And that claim was worth more than about $500,000, according to our exhibit, I think 60 and 61. The jury never actually reached that claim. They never decided that claim because over our objection, the trial court required the jury to first decide the prior material breach defense of Genash, and the jury decided that against us, and so they never reached our counterclaim. Rose Legacy is seeking, on this issue, a new trial on its counterclaim on the ground that the first breach defense does not bar its counterclaim because, one, the breach caused with the license agreement was cured either when the tower crane came down on July 15th, 2019, or at the latest when the license agreement expired at the end of 2019. And secondly, because
the license agreement, you're referring to the airspace?
Yes, Your Honor.
For the crane to operate above the restaurant?
Yes, Your Honor.
Okay.
And then secondly, the right to assert the first breach defense as grounds for not performing was waived when Genash continued to enjoy the benefits of the lease until Rose Legacy terminated the lease at the end of September 2021. The 4 or 5 key facts, I think, on this issue are that the license was discovered in April 2019. The tower crane was disassembled around July 15th, 2019. The license agreement by its terms terminated on December 24th, 2019 with the end of construction. Genash never took any action to terminate the lease. Genash remained on the property until September 30th, 2021. It paid either full rent or partial rent for those months, and the partial rent is the basis for our counterclaim. And it only left the property because Rose Legacy terminated the lease. So under those facts, we contend that the first breach defense doesn't bar a claim for damages accruing, again, either after July 15th, 2019, or at the latest December 24th, 2019, because the disassembly of the tower crane ended the breach. And if that didn't end the breach, then the expiration of the license agreement ended the breach at the latest by, again, December 2019. And then secondly, it's undisputed, Genash never terminated the lease. They remained on the property for another, depending on where you count from, anywhere from the date of discovery of the breach, 2 years and 5 months, from the end of 2019, a year and 9 months. A material breach does suspend the obligation to perform, but it doesn't suspend it forever. A non-breaching party generally has to allow the opportunity to cure. That's clear. If the breach is cured, then the non-breaching party has to resume performance. If the breach isn't cured, then the non-breaching party has a choice, either terminate and sue for damages for total breach, or keep the contract in place and sue for damages for partial breach. But if you take the second option, you still have to perform. And the facts show that's what Genash did. It didn't terminate the lease. It stayed on the property, and it's actually even though this meeting that occurred at the end of 2019 between Ms. Agnoletti and Mr. Himmel, even though that's hotly disputed what that meant, it is undisputed that after that lease, Genash resumed paying full rent and continued doing so until COVID, when it asked for forbearance. So we have a situation where a party is asserting the right not to pay rent after a breach is after a breach is cured, and after it remains on the property and continues performing under the lease. there's sort of four main cases on this issue that the parties have argued a lot about, and it's W.F. Holt, 94th Aero Squadron, Madden Phillips Construction, and Old Hickory Coaches. And we think Madden and Old Hickory are the closest to our case, because in both those cases, you've got a situation where the non-breaching party, well, like in Madden, a dispute arises between the developer and the contractor keeps working, and the developer doesn't terminate until 8 months later on the grounds of the contractor's prior breach. And this court held that no, after the developer waived the right to assert that prior breach to terminate the contract by continuing to accept performance for 8 months. And then Old Hickory Coaches, I think, is even closer, because that involves a multi-year situation where at the end of several years of accepting performance, the original non-breaching party attempts to assert that old breach as grounds for its non-performance. And this court said no. And again, here we have anywhere from 1 year and 9 months to 2 years and 5 months of performance. Genash has claimed that none of this really matters because the breach was incurable, because Rose Legacy lacked the ability to terminate the license agreement, to make any of this stop. But the case law doesn't hold that the non-breaching party has to be the one to cause the cure. And here, really, the breach was a failure to deliver exclusive possession. So once the license agreement expired, exclusive possession was delivered at that point. So I don't think there's an issue on cure. And then Genash has also claimed that there was a failure to cure because Rose Legacy did not pay for Genash's damages. But we cited case law on that. Well, number one, we cited the restatement, which draws a clear distinction between cure and the right for damages for partial breach. So here, again, we don't dispute that if there was a breach, that Genash would have had a claim for damages for that partial breach. The issue is that by continuing to remain on the property, resuming paying rent, and so on, it can't then years later assert that original breach as grounds for not paying full rent. So our position is that the trial court should have granted a directed verdict on the dismissing or striking, I guess, the first material breach defense, or alternatively, it should have found that there was.
I'm trying to process your argument. Let's assume that your client was the first to materially breach, but at some point you're saying that breach ceased.
Yes, Your Honor.
So what is the legal consequence of that as to the before ceasing the breach and after ceasing the breach? What's the legal consequence?
If I understand your question, and please correct me if I don't. For the breach period, whatever damages accrued during that period, Genash would have the right to sue and recover from the landlord. Okay. Once the breach is cured, assuming at that point there are no more damages accruing, if there were still some damages that accrued post-cure, they would have the right to recover that too. But what they wouldn't have the right to do is to later, after they've breached their obligations, subsequent to cure, subsequent to that point, what they wouldn't have the right to do is say, oh, no, you can't sue us for this post-cure breach because you breached first. That would allow an absurd situation where, by that logic, Genash could have essentially remained on this property indefinitely and never paid any rent. That's just not how it's supposed to work. So fundamentally, we're seeking a new trial on our counterclaim, and whether it's by holding that the trial court should have dismissed the first breach defense, or whether it should have found there's no material evidence to support it as applied to the post-cure breaches. Or we've also raised, we raised an instructional issue because the trial court declined to instruct the jury that cure doesn't require paying damages, and also that that finding that the landlord cured the breach doesn't preclude the tenant from recovering damages. We've offered multiple routes by which we get to the ultimate result, which is where we get a new trial on our counterclaim, that a jury actually gets a chance to decide the merits of our counterclaim. Briefly, I want to address the argument that you don't need to reach any of our issues because we didn't challenge the jury's fraud verdict. And I think that's the other main issue I want to address in my remaining time. Our position is that the jury's fraud verdict is not an independent and alternative ground for affirming the jury's contract verdict because the jury awarded no relief against landlord on the fraud claim. The way the jury instructions and verdict form were constructed by Genash, it was such that the jury was required to decide contract damages and then separately decide fraudulent inducement, and if it decided that the elements of fraudulent inducement have been established, to then decide whether rescission was warranted. That's the only relief the jury was required or asked to decide on fraud. The jury found the elements of fraudulent inducement, which we disagree with, but the jury found against Genash on rescission. So no relief was granted in that. And we submit that logically, a jury verdict granting no relief on one claim cannot be an independent and alternative ground for affirming a jury's verdict granting relief on a different theory, a different claim. And we think it would be unreasonable and unfair to hold that Rose Legacy has waived all of its claims by not appealing a portion of a verdict that granted no relief. It just does not compute as far as I can tell. We have asked in our brief that if you disagree with us, then we have raised a couple of issues on the fraud verdict, and we would ask that you exercise your discretion to reach that. Thank you.
All right, thank you, Mr. Adams. We'll hear from you on rebuttal. Good afternoon.
Good afternoon.
And will the two of you be sharing time?
We will not, Your Honor.
You'll be taking the 15 minutes. All right.
Yes, thank you.
Thank you.
May it please the court, Amy Mohan and Alex Carver on behalf of Genash, LLC. Rose Legacy has raised a dozen or so issues on appeal, but the plain facts of this case, which the jury found, is that the landlord secretly gave a license to the neighboring Drury Hotel, which materially interfered with Genash's business, so much so that it could not open its patio for an entire season. And this verdict came after a week-long jury trial with numerous witnesses, dozens of exhibits, and the jury unanimously found for Genash on every single one of its claims, including fraud and the inducement, and rejected each of Rose Legacy's claims and defenses. And as this court is aware, the standard of review for a jury verdict is a high hurdle. This court has a duty to uphold a jury's verdict whenever possible and to only set it aside if the findings of fact are not supported by material evidence. And here, none of the issues raised by Rose Legacy merit a reversal of the jury's verdict. I'd like to address the two issues that counsel addressed earlier, as well as the air rights argument, and of course welcome any questions by this court. First and foremost, the jury's finding of fraud independently supports its award of lost profits damages. The court does not need to consider Rose Legacy's arguments related to breach of the lease because the jury here found another independent ground for the award of the lost profits damages. And Rose Legacy has not challenged the finding of fraud on appeal, and this court can therefore affirm the judgment of the approximately $287,000. Genash had a claim for breach of the lease and also had a claim for fraud and the inducement, but the damages are the same. The fact that there was a breach of contract, breach of the lease, caused GE Nash to not be able to open its patio for an entire season, lost customers, and caused $287,000 in lost profits damages. The fact that the license was not disclosed to GE Nash and there was a tower crane above the patio for a period of time, that caused GE Nash to not be able to open that patio, and therefore it lost those customers. The appropriate amount of damages is the same for both the breach of contract claim and the fraud claim. Earlier, the appellant stated that the jury only was able to determine the amount of damages for the breach of contract claim. There was one space on the jury verdict form for the amount of damages for the breach of contract claim because counsel was concerned, and there was argument about this, of having inconsistent verdicts, of having a different number for breach of contract versus fraud and the inducement, even though the damages were the same, and those were lost profits damages testified to by the experts in this case. And the jury found by clear and convincing evidence that every element of fraud had been met, none of the defenses applied, and they also found by a preponderance of the evidence that all of the elements for breach of contract had been met. And this court most recently in Reguli versus Anderson found that if an independent ground for damages has not been challenged, then that has been waived. And here this court does not need to consider any of these breach of the lease arguments because the fraud claim supports the lost profits damages verdict by the jury. Second, even if this court were to entertain the arguments as to the breach of the lease claim, those arguments fail as well. The jury specifically found that Rose Legacy committed the first uncured material breach of the lease, and that finding should not be overturned. Again, it's a jury's finding, and that standard of review is high. And also, Rose Legacy does not dispute on appeal that it materially breached the lease when Mr. Agnoletti provided that license to the Drury Hotel. And so the real issue here is cure, which is a question of fact that the jury found, and these same arguments were presented to the jury. They were given appropriate jury instructions, and they determined that it was an uncured breach, and in fact found on the verdict form that there was a breach, it was material, and that it was uncured. And therefore, those findings of fact should be upheld because there was material evidence.
Now, you say it was uncured.
Yes.
Are you suggesting that all the way until the termination of the lease?
Yes, Your Honor, that it was uncured.
Well, what is the consequence of the termination of the air rights crane operation agreement? Is that inconsequential?
No, Your Honor, it's not inconsequential. Certainly the tower crane, when it came down, that did allow GE Nash to eventually open its patio, but there was nothing done to cure the breach by Rose Legacy. And all of the cases in Tennessee...
The breach stopped. So I guess maybe we're splitting hairs on curing versus stopping.
Your Honor, the breach stopped because the tower crane came down. The breach did not stop because Rose Legacy took some kind of action. And Rose Legacy is not cited to any cases that state that happenstance or the actions of a third party or the passage of time can cure the breach. In fact, in the jury instructions that Rose Legacy submitted to the trial court, it stated that the breaching party had to take some type of substantial action. The breaching party can't just sit back and not do anything. And on page 21 of Rose Legacy's reply brief, it states that GE Nash could have temporarily suspended its obligations under the lease during the time that the tower crane was hovering above. But in fact, GE Nash did not do so. GE Nash continued to pay rent timely and in full throughout the entire period. And
I thought it made partial payments later on.
Your Honor, during the COVID-19 period, it made partial payments due to an agreement that it had made with the landlord, but it continued to pay the amount agreed upon throughout the lease. Right. The other issue, Your Honor, is the waiver issue, which counsel brought up. And this is, again, a finding of fact that was made by the jury. And this court has made clear that there are certainly circumstances where a party, a non-breaching party, acts as if there has been cure and goes on about its business and continues to benefit under the lease. But this court has made clear in the Madden Phillips case that the appellant cited, as well as the 94th Aero Squadron of Memphis case and the Holt case, that there's also a different set of circumstances. In the case where you've got fraudulent inducement or misrepresentation, continued negotiation, or complaining, those are cases where you're not acting like the breach has been cured. You're continuing to talk about this breach and how it can be remedied. And that's exactly what happened here. If you look at volume 20 of the record, Jeff Himmel's testimony, and Mr. Himmel is the president of Genash, and he continually complained from the moment he found out about that license through the litigation. In fact, Daniela Agnoletti from Rose Legacy said that it was annoying that Mr. Himmel continued to bring this up over and over again, even after the hotel was constructed. The jury looked at text messages from Mr. Himmel to Miss Agnoletti where he was continuing to complain during the pandemic about this fraud that had taken place, about this breach of contract, and the fact that he never received any type of remedy whatsoever from Rose Legacy because it had not been cured. They didn't give him some type of rental agreement and say, well, we'll give you a credit for this time period and we will agree that the breach has been cured. That never happened in this case, and the jury looked at all of that evidence and made a specific finding of fact that the breach was uncured, and they also made a finding of fact that waiver did not apply. And so the jury had material evidence to determine that. Also, none of the cases that Rose Legacy cites to on either cure or waiver are appeals from a jury's finding of fact or a jury's verdict. It's notable that all of the cases cited are from either a motion for summary judgment or a bench trial. And here there was a jury that deliberated for several hours after a week-long trial and made the specific finding of fact that the breach was uncured and that there was no waiver. And those findings of fact should not be overturned. Third, Rose Legacy's argument as to the air rights over the building fails on its merits because it breached the lease by demising a portion of the property to the Drury Hotel before signing the lease, and also breached the covenant of quiet enjoyment. And this argument, first of all, has been waived. Rose Legacy is bringing this argument up for the first time on appeal. It was not brought forth in Rose Legacy's motion for summary judgment. It was not raised at trial or in its motion for directed verdict. And so the argument is waived and this court does not need to consider it. Also, as stated earlier, we've got the fraud claim, another independent ground for those lost profits damages, so another reason this court doesn't need to consider the air rights argument. Also, when Genash moved for partial summary judgment, it did so based not only on this argument that it wasn't given the entire premises, but also on a covenant of quiet enjoyment. And Section 6B of the lease is the covenant of quiet enjoyment, and it is clear from the evidence here that that covenant was breached. Even Rose Legacy's own attorney wrote several letters to the Drury Hotel stating that you are, quote, materially interfering with the restaurant's ability to operate. They can't open their patio. They're losing money every day. The tower crane is dropping construction debris and other items, and therefore, due to safety reasons, they can't open it. These were words from Rose Legacy's own attorney in Exhibits 23 and 62, and they stated that there was material interference. So this court could find that there was a breach of the lease just due to the breach of covenant of quiet enjoyment in Section 6B. But if this court were to consider the air rights argument, that argument also fails because this court has ruled in the Osborne Enterprises versus City of Chattanooga case and in the Massey versus R.W. Graff case that property owners do have air rights to the extent of the space above and below to any extent that he may choose to occupy it. And so clearly, if you're sitting on a patio with a tower crane overhead, it's reasonable to assume that you at least have the ability to sit on that portion of the premises without something falling overhead. And if you look at Section 2 of the lease, it refers to Exhibit A and states that Genash was getting everything that was quit-claimed to Rose Legacy. and that there was no type of exclusion for the air rights. This air rights argument is also interesting because clearly Rose Legacy, or its predecessor, Agnoletti Properties, thought it had air rights because it gave those to the neighboring Drury Hotel. And certainly the Drury Hotel thought that its license was valid because it used 22 stories of air rights. And so this argument now on appeal that suddenly the air rights weren't there in the first place and that they didn't have these air rights to give away certainly would fail as well, because GE Nash had the right to those air rights and should have been able to have the quiet enjoyment that it was promised in the lease. Your Honor, in conclusion, this court can simply look at the fraud finding by clear and convincing evidence by the jury and affirm the lost profits damages of $287,000, and doesn't need to consider the arguments in sections 1, 2, 4, and 5 of Rose Legacy's brief, which all relate to the breach of the lease claim. The remainder of the arguments relate to the jury instructions and the jury verdict form, and those are without merit as well and harmless error at best. The evidentiary issues looked at under an abuse of discretion standard also lack merit and don't show an abuse of discretion by the trial court. This court should uphold and affirm the verdict of the jury in all respects and remand it to the trial court to set the amount of fees incurred on appeal, as those fees are provided for in section 29 of the lease. Thank you.
All right, thank you. Mr. Adams?
Thank you, Your Honor.
Do you agree that the lost profits is the same damage that they were seeking under the fraud versus the breach of contract?
The jury wasn't asked to decide that question, so the answer is we don't know. We don't know what the jury would have decided.
But no, as an element of the damage, we don't need the jury's view. Isn't the damage lost profits under either theory?
Genash could have sued for lost profits instead of rescission and rescission damages. They chose not to. They chose not to ask the jury to decide that question.
All right, so the fraud claim as presented in this case was for rescission, not for lost profits?
Yes, Your Honor, and that is crystal clear from the jury verdict.
Okay.
And briefly, Regularly was mentioned. Regularly is not in point because in Regularly the trial court expressly said, I'm denying this motion for this reason and that reason, and the appellant appealed reason number 1, not reason number 2. We don't have that here because, again, the jury didn't grant relief on the fraud claim. There's a comment that the jury instructions said that the landlord must take substantial action. I don't believe that's correct. Typically the non-breaching party in the ordinary course of things does take some action to cure a breach, but in this case, the breach, if the breach, put it this way, if the breach was not cured by the disassembly of the tower crane and the license agreement, then what could cure the breach? So I don't think there's a reasonable dispute that there was no cure. On the
Well, does curing the breach include making up for what damages there were?
The case law that we've cited, Your Honor, says no, because it all goes back to the consequences of a breach. It suspends your obligation to perform until cure, and then it says, and then the case law and also their statement says, even if the breach is cured, you don't lose you still have a claim for delay damages caused by it. So there's a distinction, and as a practical matter, if the rule of law was that curing a breach also requires resolving the unliquidated damages claim that flows from that breach, because many breaches are really an unliquidated damages claim that's going to require litigation, then it would be bad policy, I think, because it would be really hard to resolve breach disputes. But that's not the law. I don't believe, and I think the authorities we've cited stand for that proposition. For the other issues that council raised, especially the air rights agreement, we rely on all those other issues, we rely on our papers. We think they're sufficiently briefed. The last point I'd make is that complaining about damages does not prevent waiver. The waiver here was caused by their continued performance, their enjoyment of the property and payment of rent. Thank you.
Thank you both for your arguments. We'll take this matter under advisement.